Hello, how are you both?
Hi guys, I'm doing really well, thanks. How are both of you?
Yeah, I'm good, thank you.
Yeah, very well, thanks. Good to see you both. Look, I know we were going to have a chat about Practice Direction 51Z, which is the new practice direction dealing with possession proceedings. But I've actually just seen in the last hour or so, the Court of Appeal has given permission for a leapfrog appeal on, as I understand it, there's not a huge amount of information available, the legality of the practice direction itself, which I suppose really goes to underline the extent to which this is an incredibly fast-moving area at the moment.
Absolutely. Maybe, Dan, you could talk us through where we've got to with this practice direction.
Yeah, sure. So as you both know, the practice direction was in fact amended just a few days ago, earlier this week. Where we are now is that there is a mandatory stay of 90 days in respect of all possession proceedings, save for first claims governed by Rule 55.6 of the Civil Procedure Rules, secondly, applications for IPOs, and thirdly, applications for agreed directions between the parties. It's also been helpfully clarified that new proceedings can still be commenced. They'll just be stayed straight away. And also the practice direction doesn't affect the availability of injunctive relief. So it has rode back slightly from what was under the previous iteration of the practice direction, just a blanket moratorium on possession proceedings. But there's still a few gaps where the practice direction goes beyond what's in the Coronavirus Act. As you both know, the Coronavirus Act deals with specific types of business tenancy and specific types of residential tenancy, but for example, says nothing about trespassers. So in addition to this rapidly approaching appeal, then we've still got a few other practical questions, which I know we, and I'm sure a lot of our clients as well, have been trying to grapple with.
Yeah, no, just before we sort of dig into the practice direction further, I just wanted to touch on that appeal again. As I understand it, there are three grounds. But I mean, the central challenge is that legality challenge. And I mean, it seems to me, obviously, the practice direction will stand or fall on the basis of that challenge. And it's an interesting point, which I think quite a few practitioners have remarked on already. I mean, we don't know exactly what the contents of the arguments will be. But I mean, one possible approach would be to look at CPR 51.2, which is the provision under which the practice direction is made, under which usually pilot schemes are made. It deals with sort of devising new procedural methods for addressing various issues. But lots of people have remarked, I think possibly rightly, that the effect of this 90-day stay is actually substantive in character because it creates a license to occupy or a license to trespass.
Absolutely. And I think one of the key points that arises out of the amendment is the clarification it seeks to provide in relation to possession proceedings against trespassers. But rather than create an exception that excludes all claims against trespassers from the automatic stay, using the definition of trespassers in CPR Rule 55.1b, this amendment actually has created a far narrower exception that only applies to trespasser claims against persons unknown. So it seems now, at least on the face of it, we have an exception that turns on whether or not you know the identity of a trespasser. So does a known person, therefore, have a license to trespass? And the other difficulty this presents is that there will now be cases where a judge is forced to grapple with this highly subjective question of who is a person unknown and potentially seek to identify the point at which a person unknown becomes a known person. For example, if we'd never met before and I trespassed on your land and told you my name is Francesca Mitchell, does that make me a known person?
Well,
what do you think?
If I'm a landowner and I found you on my land and you started saying your name, I'd probably be covering my ears at that point, but it's a very unattractive argument. And my instinct is the courts are not going to be very sympathetic to Nelsonian blindness on the part of landowners. And they're going to be quite alive to improper attempts to circumvent the practice direction by saying there might be a person unknown.
I agree. And so in terms of how this will affect landowners, whereas previously it was fairly commonplace in trespass claims to issue a claim form against both known and unknown defendants, i.e. first defendant Francesca Mitchell, second defendant persons unknown, it seems that now, although you could issue that claim, and this amendment has provided welcome clarification that you can still issue such proceedings, the very fact, though, that you had a named defendant on it would mean that the claim is automatically stayed. It seems so odd that the focus of proceedings now is whether or not the trespassers are known individuals.
Well, I agree, and I think that is quite odd, and I just wonder why the line is drawn there, that if you're known, the claim is stayed, and if it's unknown, it's accepted from the scope of the practice direction. I mean, I suppose I could see some argument that unknown trespassers are likely to pose more of a threat to the land, or might have a sort of greater propensity to cause damage or something like that, and so the claims are more urgent. But equally, you've got injunctive relief to deal with something like that. So I'm not quite sure what the rationale is for drawing the line there.
I agree. It does seem sort of fairly arbitrary. The only thing I can think of is whether it's an attempt to prevent sort of opportunistic trespassers who are moving now in these lockdown period in response to a practice direction that stays possession proceedings.
And I think it might even, Francesca, be an attempt to only capture opportunistic trespassers and not overreach and end up capturing other vulnerable people, such as, for example, licensees. I don't know if either of you saw the recent decision about University College Hospital, where they were seeking originally possession proceedings, but because of the stay, ultimately an injunction against a woman in a hospital bed who had been a licensee, but then ticked over into being a trespasser.
Yeah, I did see that decision, actually, and it's an interesting one because on one hand, I think there was only ever going to be one result because there was an extraordinary set of facts here. This was a case about a hospital that needed more beds to treat COVID-19 patients. So it's quite difficult to see how the court would have denied them that right. But equally, normally we see injunctions granted against trespassers on a quia timet basis, where they may be in possession of adjacent land, and this prevents them from going on to neighbouring land. So it might be the case, actually, that judges are now going to be a bit more creative or willing in granting injunctions to remove trespassers from land. But the issue, I think, that exists with injunctions is the enforcement options available. Because if you've got a possession order and you get a warrant to enforce, that is good against the whole world. It's good against anyone who's on your land. And that's ultimately what you want, is you want to remove everyone from your land. But enforcing an injunction, typically you've got two options. You can sequester someone's assets, or you can initiate committal proceedings. But both of those things are ultimately sort of a roundabout way of trying to get what you want. It's not the same as actually getting a warrant and getting rid of the people who are on your land. So it seems to me that, using an injunction as a way to try and navigate around the practice direction isn't always going to be a satisfactory method of doing so.
No, it's not. And also enforceability is a real issue where time is of some significance. If, for example, you're worried that there's damage being done to the land. I mean, I know that one of our colleagues had a case where there were some trespassers in a wine shop who were literally drinking the wine all the time they were there. So the efficiency and the speed of possession proceedings was a real advantage as compared to something like an injunction in that case.
There are other huge practical ramifications from this, particularly, as you say, in relation to delay. So although this is a 3-month stay on the face of it, in reality, there will be a huge backlog of claims once the stay is lifted.
Yeah, I'd had the same thought. I really agree. I mean, there are going to be new claims, potentially more new claims in 3 months' time than there are now because of the economic circumstances in which we find ourselves. So that is a concern.
Absolutely, and the sheer scale of possession proceedings gives you a sense of how long this delay will be. So in the Master of the Rolls letter, his response to the PBA and the PLA, he made the point that the county court alone had almost 140,000 possession claims in 2019. So if there'd been this 3-month stay last year, that would have been, 34,500 possession claims would have been affected. The sheer numbers here are enormous.
They are, and stays are also, of course, a problem for parties who maybe have a hearing just after the expiry of the stay. Then got quite an unpalatable choice between either risking incurring costs during the period of stay, which may or may not be recoverable, the authorities are slightly conflicting there, or vacating the hearing in circumstances where, for the reasons you say, it might be months and months before you can get back on. But anyway, we could talk about this all day. That's been really useful. Thanks ever so much, guys.
It's been great. Really nice to see you both.
Nice to talk, guys. Chat soon.
Bye.
See you soon.